All rise. The Honorable Chief Justice and the Associate Justices of the Supreme Court of California. Hear ye, hear ye, hear ye. The Honorable Supreme Court, City en Banc, is now in session. Please be seated.
Good afternoon. Welcome to oral argument. The clerk may call the calendar.
Good afternoon. The Supreme Court of California oral argument calendar in Los Angeles, California on Wednesday, December 6, 2017 at 2 p.m. Case number is 241231, the People Petitioner versus Superior Court of Riverside County. Respondent Pablo Ulysses Lara Jr., Real Prime Interest. For petitioner, Mr. Donald W. Masterchat.
Good afternoon. I'm ready.
For Real Prime Interest, Ms. Laura Arnold.
Good afternoon. I'm ready.
Case number is 097558, the People, plaintiff and respondent versus Todd Jesse Garton, defendant appellant. For appellant, Mr. Jeffrey J. Gale.
Ready, Mr. Garden.
And for respondent, Mr. Daniel C. Burstyn.
Ready, good people.
Thank you. And on the first matter, we welcome the Honorable Ronald B. Roby, Associate Justice, Court of Appeal, 3rd Appellate District. And whenever you're ready, counsel.
Thank you, and may it please the court. Donald Ostertag, Deputy District Attorney from Riverside County, on behalf of petitioner. Proposition 57, as it relates to juvenile court law, did one thing and one thing only. It altered the manner in which a case may be transferred from juvenile court to adult court. Once a case is already properly in adult court, everything impacted by Proposition 57 is necessarily complete. It is for that reason that the Court of Appeal here erred in holding that Prop 57 could be properly applied prospectively in this case. Given that, I believe our focus shifts to whether it can be applied retroactively. There are two possible ways that this could be applied retroactively. The first would be if there was an express statement of intent, a clear express statement of intent within Proposition 57 of supporting ballot materials for it to apply retroactively. Here, there simply is not. So that turns to whether Estrada would apply to this case. And Estrada, at least in the manner in which this court has previously interpreted it, has never been applied this broadly. It has never been applied to a procedural change in the law, even one that may potentially benefit criminal defense.
But so, counsel,
doesn't Proposition 57 at least provide a possibility of reduced punishment for juveniles?
Absolutely, it does.
And what did Estrada do?
Estrada was essentially a quest for legislative intent. Estrada was searching for, was there an intent other than vengeance for not applying?
Did it reduce the punishment?
Estrada directly reduced the punishment for one specific criminal offense.
In that vein, isn't it like this case, reducing the punishment for juveniles?
Not at all. And the reason is that Proposition 57 did not directly reduce punishment. Certainly that is a potential collateral result of the procedural mechanism that was in place. But furthermore, it doesn't apply to one specific offense. Now, this court, in its 52 years since Estrada came out, has only applied Estrada in the sense that it has directly reduced the punishment scheme for a specific offense or enhancement. It's altered the elements of a specific offense or enhancement, or it's decriminalized conduct or created a specific defense.
But why logically wouldn't the inference that was recognized in Estrada also apply if, for example, the legislature were to determine that a particular class of defendants, no matter what their offense, should only be subject to a maximum term of imprisonment of something lower than the law otherwise prescribed? Why wouldn't the logic of Estrada apply equally in that circumstance?
The problem that I have with that is that Estrada has never been applied in that manner before.
Well, certainly, but why doesn't the logic of Estrada apply in that circumstance?
Well, the underlying logic of Estrada was, again, a quest for legislative intent, where in that case, there could be no other intent of the legislature other than vengeance for not applying this retroactively. Here you have a case where there are a host of other possible intents here, very reasonable ones for not applying this retroactively. And the disruption that can happen in criminal cases, the additional litigation, the additional expense.
But aren't those things also always true in any case in which Estrada clearly applies? Whenever the legislature retroactively reduces the punishment for a particular offense, isn't there also some disruption to the system?
Absolutely, but never to this scale and never to this extent. And the voters were specifically given a fiscal analysis in support of Prop 57, which again is going to relate to everything that must happen before a case must be transferred. That's what the voters were told. Now, if we're altering that and we're saying that this is going to apply to cases even after they're already in adult court, that opens up a host of different issues, a host of additional litigation that's going to be
But it's a limited group of folks, is it not? I mean, we are talking, this case, however we decide it, will really only affect those folks who were pre-Prop 57, whose cases were not yet final. So even if there is the side effect of additional hearings or resources in transfer hearings, if they occur at the juvenile level for the adult court transfer, I mean, we're talking about a pretty limited sum compared to the greater intent of Prop 57 for an entire class of young people.
I think when you compare it to criminal law as a whole, sure, but we're talking about every single felony offense committed by a 16 or 17-year-old, any of a long list of offenses committed by a 14 or 15-year-old. This is not a limited small number of cases.
Aren't we talking about cases in Mr. Lara's position where his case had progressed to a point, but then Prop 57 passed, and so now we're deciding whether a person like Mr. Lara, who is in adult court, should be sent back to juvenile court?
That's correct, but if we apply Estrada in this case, or if the court were to apply Estrada in this case, we're opening this up to everybody who's not yet final on appeal. What the voters who passed Proposition 57 intended was for this to happen before a case can transfer to adult court. Once it's already there, everything contemplated by the voters, as far as Prop 57 is concerned, is necessarily complete. Now if we go into prison and we take people who are waiting for their appeals to finalize, and we bring them back to juvenile court while their appeals are still pending, not only does that frustrate their pending appeals and cause additional delay in their pending appeals.
Well, why would that be a problem if the potential of applying it would maybe a lesser sentence to them? Why would they worry about thwarting their appeals by taking longer if they're given a better opportunity?
I'm sure the criminal defendants would appreciate that. I don't know that the people's due process right to a speedy resolution would appreciate that. I don't know that the victims
Well,
and their
wasn't the
families.
clear intent of the public in voting for this to recognize that the system then in effect was not entirely fair? It was not a neutral person making a decision as to whether they should be tried adult or juvenile court?
I think it must have at least been contemplated that at least there was the potential that was being created by this new law that some people would no longer be punished in the adult court system, that potential was there. But again, this is different than directly reducing punishment for a specific crime. This is imposing a procedural...
No, we were talking about the policy implications of what's going on, not what you're talking about now. I think the policy was that people wanted a different way of doing it. And why shouldn't people, defendants who are not yet completed in this, get the benefit of the people's decision to make it a different system?
Well, again, that's going to be an application of Estrada broader than it's ever been applied in its 52 years. And we have the voters that specifically voted on this that we're required to presume we're aware of existing laws, including the way this court has interpreted and applied Estrada. Now we're delivering to them an expansion
But
necessary...
you're making it sound as if we would be doing something catastrophic. Isn't the Chief Justice right that this is a limited number of cases?
It's limited in the sense, as opposed to the entirety of criminal law, sure. But again, this is going to be applied to every single felony offense committed by a 16 or 17-year-old, and all of a long list of offenses committed by 14 or 15.
But let me follow up on that, just to be very clear, because it seems like you're putting a lot of weight on this argument, and it does matter what the consequences are of an interpretation at some level. But you think that if we find for the defendant here, there's no way that we can limit the logic of our decision from doing what? From applying to juveniles across the board and then doing what? Exactly.
Well, of course, this court could include language limiting it to this case. Sure.
Of course, yeah.
But it's still going to necessitate a broader application of Estrada than it's ever been applied. That's an expansion of Estrada that could have never been predicted by the voters.
Well, perhaps, but then since you keep talking about how we've applied it, let me read you a little bit of what we said in Conley and tell me what words here you disagree with or how you would apply them to this case. So the words are, the Estrada rule rests on an inference that in the absence of contrary indications, the legislative body ordinarily intends for ameliorative changes to the criminal law to extend as broadly as possible, distinguishing only as necessary between sentences that are final and sentences that are not. So I'm looking there for language like a quest for legislative intent, which is how you described the Estrada rule. It seems to me that we're talking about it in a quite different way, at least in Conley. Is that not the case?
Conley was a different case than what we're dealing with here, but something this court also said in Conley was that it would not be so simple as simply substituting a lesser sentence. And that's also what we have here. This is dealing with a pretrial procedure, not with the imposition of a lesser sentence, not with a different sentencing scheme or different elements.
I'll grant you that this case is different from Conley, but let me just direct your attention again to sort of the logic of what we said. And I mean, here are the key words from my perspective, and tell me how you think that these words apply here. The Estrada rule rests on the inference that in the absence of contraindications, the legislative body ordinarily intends for ameliorative changes to the criminal law to extend as broadly as possible. Is this an ameliorative change in criminal law?
I think it's ameliorative in a literal sense of the word, but not in the term of art as the Estrada jurisprudence has applied the word ameliorative. I think it's ameliorative in the sense that it was intended to improve upon a situation in the law that the voters thought needed improving upon. It's not ameliorative in that it provides a direct lesser sentence for juveniles. That potential is certainly there. But again, I think indicative in both that statement and in Estrada itself is that there is no other possible reasonable intent there by the legislative body here, the electorate, for not applying it as broadly as
That's
possible.
not quite what we said. I don't want to just keep on going on this point, but let me just take one last pass at this for the moment at least. It says it rests on an inference that in the absence of contraindications, so what are the contraindications here, the strongest ones?
The contraindication here is that there is a very reasonable intent other than vengeance for applying this only in a prospective manner. And that would be not disrupting criminal proceedings. Everything here is intended to apply before a case winds up in adult court. Once it's already there, we're dealing with a whole host of other issues. For example, what happens when a case goes back after there's already been these proceedings in adult court to those adult court proceedings? Is evidence that's admitted to preliminary hearing relevant or admissible at this juvenile detention hearing? Is findings or conclusions that were found in the adult court, competency findings, rulings on evidence, is any of that come into play in the juvenile court hearing? These are all disruptions that are going to cause future litigation and future issue in all of these cases. And you bet that if any one of those, presuming a majority of those cases are ruled appropriate for adult court, which under this law I think the majority of those are going to wind back up where they started in adult court. Then we have additional issues being raised on appeal. We're supplementing the appeal with additional issues that the trial court abused its discretion. What the voters here need is finality and repose. And that's what this rule allows for. By applying Proposition 57 to cases like this, to applying Proposition 57 to all cases that aren't yet final on appeal, you rip away the finality, you rip away the repose, you create additional issues that still yet need to be litigated. That's not what the voters
You have pointed out why you think that this case is different than Estrada. Is it also different than Brown, People versus Brown?
Factually, it is. But
And didn't Brown deal with future conduct?
It did, yes. But the interesting thing about Brown, I mean, every case factually, when you're looking for a quest or you have a quest for legislative intent, is going to be a little bit different. And Brown did, yes, ultimately deal with 4-19 credits and future conduct. But what this court did in Brown is it expressly stated yet again the narrowness of the Estrada rule. That was reaffirmed in Hadjic and Vo, and it was reaffirmed in Conley. And that's a common theme in this court's Estrada jurisprudence.
Well, can I interrupt you? Because you talk about the Estrada rule, which was from 65, and it was a court-made rule. And as we have all recognized, Estrada started out as recognizing the ameliorative effect of a particular statute affecting punishment. And that is when it would be, when the new statute would lessen the punishment. But then 4 years later came Francis. And Francis, in 1969, sort of softened Estrada. Estrada grew. Estrada now was applied to potential or the possibility of lessening punishment. So Estrada itself has shown to be a little bit, I think, more flexible than you keep calling it as the Estrada rule limited to punishment only. And now we're faced with, I think, maybe as Justice Cuellar has indicated, other indications for the application of the Estrada rule to a class of juveniles and a limited class of juveniles as well, who would then get the same treatment that future juveniles charged would receive. And I'm not seeing why, apart from the straitjacket of the Estrada rule, that should require us to find in your favor.
Well, I would certainly agree. I don't mean to imply that Estrada is a straitjacket. In fact, this court has said the very opposite. I think it is an amorphous rule, and it has to bend and flex for different cases as they come along. Now, Francis was a case that did directly alter the sentencing scheme for one specific crime.
Right, for the possibility.
Correct. And what I think applying Estrada in this case would do is it would untether Estrada from its very contextually specific application to a particular criminal offense. Now we're applying it to, although a somewhat limited group of people, this is still a very large group of people, and this is going to lead to substantial litigation. And it has a whole additional host of problems that I can see if it were to be applied in a case like this. For example, Penal Code Section 1170.17 is a law that if Estrada is going to be applied here, is completely null and void. Prop 57 will now render that specific statute that is expressly applicable only to direct file cases pre-judgment completely null and void. There's going to be no application in the law left for 1170.17.
And say for a moment why that matters. Why does that matter?
Well, I think it's important, and this court has said before, not to interpret statutory language in a manner in which renders other statutory language a nullity. I think if Proposition 57 was intended, which ultimately Estrada is a quest for that intent, if it was intended to apply to all cases not yet final on appeal, they would have addressed 1170.17. They know how to put in the measures. They know how to put in the initiatives.
But if you're correct that it's null and void, isn't it going to be null and void eventually anyway, once we're sort of past the point of dealing with the individuals whose judgments have not yet become final?
Sure, I think at some point.
So if the inference to draw here is that the voters could not have intended to enact legislation that rendered another existing piece of the penal code null and void without saying something, that is already the case, is it not?
Not right now. And I think it's very indicative to the voters' intent with enacting this, because this was left on the books for a reason, and it's to deal with cases like this, with cases that aren't yet final on appeal. It's intended to deal with those types of cases. So,
do we have any indication in the history of this initiative that the voters were aware of 1170.17 and were advised how it normally operates in the context of a proceeding against a juvenile?
I'm sorry. I know that we are required to presume that the voters were aware of existing laws. So regardless of whether it was directly mentioned or not within Prop 57 or the supporting materials or the legislative history of that initiative, I'm not aware of it being in there. But we are required to presume that the voters acted with awareness of existing laws. That is one. And now we're going to render it completely null and void where it has no application whatsoever if this is going to be applied retroactively under Estrada. To me, that's very troubling. It's something that could have been spoken to. And this is something, the initiative process knows how to make statutes retroactive if they want to. If this was intended to be applied...
The initiative process, I'm sorry, I just want to understand that statement. The initiative process knows how to make statutes retroactive. Who or what is the initiative process? I mean, in what sense does it know something?
Well, I should say that the drafters of an initiative, and I apologize for my imprecise
That's a helpful
language,
distinction. I mean, the details matter here. We're talking about the voters, we're talking about the initiative drafters, we're talking about the process.
I'll correct myself and say that the drafters of an initiative know how to present the voters with a new law that would be applied retroactively.
But it's not, okay, so just to understand and calibrate finally what your position is, I'm trying to think through what the implications would be of accepting your view. So your view seems to be ordinarily when a particular legislative enactment, whether initiative or a statute, changes some existing provision of the penal code, we would expect that would be explicitly referenced. But tell me if your position is even stronger than that, which is in no circumstance where that's not explicitly mentioned can we conclude that a previous portion of the penal code has been affected.
I don't necessarily know whether under no circumstance whatsoever that could be the conclusion. I do think here that not speaking to it is further evidence of intent for this not to apply retroactively. So by leaving that on the books, it shows the voters, presumed aware of existing laws, know about this law and know its purpose. Right? And you look at, if the voters had intended for this new law to apply retroactively to all cases, even after conviction and after sentence, they would have said so like they did with the other half of Prop 57. If you look at other initiatives...
Let's assume that, for purposes of oral argument, that Proposition 57 does not apply retroactively. Is Laura entitled to a transfer hearing under the rationale of the Court of Appeal in this case?
No, and for the reason that I opened with, Your Honor. The reason for that is because once a case is already in adult court, everything that was changed by Prop 57 has already happened. It's complete. So in order for Proposition 57 to apply once a case is in adult court, it's necessary to move backwards in time, go back to juvenile court, proceed under the legal fiction that there have been no proceedings in adult court, that the case was being initiated anew, doing a detention hearing, doing all of the initial stages of the case, making the transfer motion, and only then returning it back to where it started. That's, by its nature, a retroactive application of the law. Proposition 57 dealt in its entirety with how to transfer a case to adult court. Once it's there, we're dealing with things that are necessarily complete in the past.
Counsel, so the Court of Appeal was wrong?
The Court of Appeal here was absolutely wrong.
Counsel, do you have any estimate of how many cases you think would be affected?
I don't know exactly how many cases we're talking about that aren't yet final.
Are we talking about hundreds or thousands?
If I had to guess, I would probably say close to 1,000, if not more. I mean, this is, like this court knows, appeals take a long time to finalize. Oftentimes they come back with modifications. To apply this retroactively under Estrada is going to open up a whole host of cases, and it's going to lead to additional litigation, additional confusion, and likely additional...
But aren't these cases around now because of the uncertainty of whether or not it's retroactive? And once we decide that, yes or no, don't they go away?
I think that addresses that question. I think that addresses the question of retroactivity, but then that opens up additional questions, such as how do we deal with forced severances of charges and defendants in cases? What do we do with the evidence that was already admitted during the proceedings in adult court? How, if at all, is that relevant when we're back at the hearing now in juvenile court? These are all additional issues that are still going to need to be resolved.
Aren't those issues answered when 1170.17 applies? 1170.17 applies when a juvenile is in adult court and is convicted of a lesser included offense and not the charged offense. And then the court has a requirement under that kind of context of a conviction to either treat the accused as a juvenile or order a fitness hearing. So under those circumstances, and I don't know how often that happens, but when that's the case, the court has that process. The court knows how to do that.
Sure, I think that's one very specific process. If you end
right,
up
but
with
that is the process found for in 1170.17. So even though there are maybe a host of steps taken under the circumstances of finding retroactivity here, those aren't circumstances that the courts that are foreign to the courts. They're able to do this. They have done that. In fact, there's a statute that's irrespective of Prop 57 has provided them that opportunity.
Well, you have to remember that people have a due process right in prosecutions they have a due process right to a speedy trial and to be aware of all the laws in a case. These are considerations that go into play when you're charging a case. Now, if you charge a case a specific way and you don't get the conviction that you charged for whatever reason, I think then that sort of takes away or diminishes that due process right, or it justifies that different treatment in that case. But now applying this to all cases is really stripping the people of their due process right to be aware of all laws at the time they charge a case.
I would argue that Prop 57 was intended to strip the people of the right to take a juvenile from juvenile court directly to adult court. I mean, that was the purpose. One of the purposes of Prop 57 was to give that discretion back to the trial court and not to the DA.
Absolutely.
So I mean, so the stripping of due process, and discretion here is inherent in the statute itself.
Well, with all cases moving forward, there was absolutely no intent to apply that retroactively.
I guess that's what we're talking about here.
Sure. And by applying that retroactively, you're going back in time and stripping the DA of the ability to be aware of all existing laws when they charge a case. Now, moving forward, we're aware of that law. We are aware that our rights have been stripped away, and we know how to take those considerations into account when we're deciding how to best charge a case. Now, if we're applying it back in time, we're presuming that we had that knowledge, when in fact we didn't. So we may charge a case as a course of conduct. Law enforcement may stop their investigation on a course of conduct molestation case, for example, assuming we don't need more evidence to prove particular offenses that happened after the person was 18, because this can be direct filed. We have enough as it is right now. And now by sending it back, we're really causing a disruption in that case. We're causing a forced severance of some of the counts. We're at a point now where that...
Why does that change the way you investigate the case?
Well, say, for example, we find out that there's a course of conduct on a young victim in a case. And that conduct, the acts occurred between when the defendant was 16 to potentially until 19. But we don't have any specificity yet as to when the exact acts happened as far as age is concerned. There's potentially additional investigative steps that can be taken to flesh that out and determine that. But those wouldn't be necessary under the prior version of the law at the time the case is charged, because it can be direct filed anyway. We have a statute for course of conduct. We can proceed under that. But now by stripping that away, you're placing the people in a position where now we're going to potentially have to send the whole case back if it's a course of conduct case, sever certain charges off and send to juvenile court while there's simultaneously charges proceeding in adult court. That really strips away a right we have. Now, I'm not quibbling with Proposition 57, with the validity of the law, with its widespread impact, with all cases going forward, with what it did to strip prosecutors of their discretionary power to direct file cases.
Counsel, I think you make a point that I think is quite plausible, that if we were to find that Prop 57 has retroactive application, we'd be dashing the expectations that the people had at one point. So if I stipulate to that for the moment, let me go back to Estrada and try to unpack a little more what you mean by quest for legislative intent. Because, of course, that is probably what you'd be telling us we need to do if we'd never decided Estrada. So I want to understand a little bit more what you think Estrada did, even if I grant you that we've interpreted it in subtly different ways and maybe it means something different now than what it did when we first decided it. How does the presence of Estrada in our jurisprudence change your argument in any way, given the weight you're putting it on? It sounds like your understanding of Estrada as a quest means that it doesn't really represent a rule. It represents more an underscoring that we are looking for some kind of purpose or intent.
Well, I think without Estrada, my argument becomes a lot easier, that's for sure. But with Estrada being on the books, it's a situation where there is no intent discernible. There is no clear intent discernible as far
And
as...
isn't Estrada precisely about what we do when there is no intent discernible?
Yes, absolutely.
So, so your argument here, I guess, would be there's a pretty clear intent going the other way? Or is it there's a plausible intent that I can tell you about, which you have to weigh, but as soon as I can articulate a plausible alternative, then Estrada falls away?
It's not that just simply articulating a plausible alternative, but here there are some, right? So I think Estrada in that case was limited to a situation where there was no other plausible alternative. There was no other intent aside from vengeance to apply this law retroactively. It needed to be applied as broadly as possible.
But is that right? I mean, even in Estrada, I grant you that the disruption entailed by the ameliorative change at issue in Estrada is not really comparable to the kinds of disruptions that you're concerned about here. But there was nevertheless disruption. We're talking about reopening cases that had already been completed and were pending on appeal at that time. It wasn't as though this was a categorical reduction in the penalty for a particular crime. The reduction depended on the particular elements proved, which had changed between the time that the defendant in that case had been convicted and the time that the legislature had made this amendment. So I guess I'm having trouble figuring out exactly how we should allow the prospect of disruption to figure into the inferences that we draw about legislative intent to apply this ameliorative change retroactively. When is too much disruption too much to continue to apply the Estrada inference?
Well, in Estrada, it was an easy fix. The legislature determined the sentence was too great. It needed to be lessened.
But it didn't do so categorically for all individuals who had been convicted under that particular provision, right? I mean, it created different tiers, essentially, of the provisions, some of which were entitled to lower penalties and some of which weren't.
Correct. But it was still a simple fix there. The sentence is too great. Send it back for a sentencing hearing. Let's see if this reduced sentence applies.
But even if we accepted that, counsel, I think the burden of Justice Kruger's question is, assuming that it was at one point an easy fix, if your argument is it's too heavy a load now for Estrada or anything to bear, you can't decide it that way, where's the line exactly that makes it too big a burden?
I don't know exactly where you draw the line. I can certainly say that in the 52 years since Estrada has come out, it has never been applied to a procedural change in the law. It has never been applied this broadly to any felony offense committed by a group of people. It's simply never been applied that way. And now by applying it that way, it's giving the voters a very different law than the one they voted on. It strips them of the clarity and candor necessary that they have in their democratic initiative process. It provides them with a much more of a law than they voted on. And as we know, we need to provide the voters with the exact law they voted on, no more and no less. If Estrada is applied here, they're being delivered with a very different law than what they intended and what they passed in the election.
Mr. Ostertag, you'll have 4 minutes for rebuttal.
I'll save that time for rebuttal. Thank you.
Thank you.
Good afternoon. The Public Safety and Rehabilitation Act of 2016, that's the name of Prop 57. It was, I think, the fifth in a series of sweeping criminal justice reforms that we've seen since 2012 when People v. Brown III was decided. The reason why the court in 2012 characterized the Estrada rule the way that it did is because up until that moment in California's history, the only changes in the law that we'd seen which were designed to lessen punishment had been crime-specific or statute-specific, with one exception, which was the first Prop 36 in 2000. That was the one that drug treatment and probation instead of jail. That covered a whole category of crimes. However, by its terms, it applied only expressly to crimes committed after its effective date. But since Brown III was decided, we've seen a lot of reforms in criminal justice and juvenile justice in California. We saw Prop 36, the Three Strikes Reform Act, to which Estrada would apply, but there is a saving clause. So we declined to apply Estrada to Prop 36 because of that saving clause. We saw Prop 47, categories of crimes for not all but some offenders, creation of a new crime of shoplifting, which isn't technically a lessening of punishment for anything, but had the effect of lessening punishment for certain conduct. We saw Prop 64, the marijuana initiative. Again, the punishment, the degree of a whole category of crimes was changed. And Prop 57, the Public Safety and Rehabilitation Act of 2016, was one in those series of reforms.
But would you agree, counsel, that there is something different about applying Estrada here, or would your position be there's absolutely no difference between everything you've just described in this? How much of a difference would you acknowledge?
I don't think there's any difference.
Why not?
Because when the voters were presented with Proposition 57, and it did a number of different things, all of which were really geared toward not spending money so much on lengthy prison sentences that are known not to enhance public safety, to implement evidence-based practices, to focus on rehabilitation, particularly for juvenile offenders, to allow for discretion in the early parole of nonviolent drug offenders, to allow for enhanced credits for people who are working toward rehabilitation during their time of imprisonment. The voters weren't really that concerned with the address at which cases are filed, whether it's in this courthouse or this courthouse. They weren't really concerned about whether it's assigned an RIJ number or an RIF number. What they were concerned about was the way that many people, and in particular here juveniles, are treated in the criminal justice / juvenile justice system, how they're treated in terms of delinquent conduct / criminal conduct that they're believed to have engaged in as a child. And treatment, as a voter understands it, is tried and punished.
So under that approach, tell me how you would articulate the limits of Estrada. What would be outside of Estrada?
I actually wrote this down.
Because you knew I was going to ask.
I did. I read the note. Well, I figured when you ordered me to brief it, you might want me to talk about it. So I think the question I thought you were going to ask me is today, what would we say the Estrada rule is? Kind of paralleling
Close enough.
Justice Werdiger's language. Had Brown III been decided today, the court would have said it differently. Estrada is today properly understood not as weakening or modifying the default rule of prospective operation codified in Section 3, but rather as informing the rule's application in a specific context by articulating the reasonable presumption that a change in the law mitigating the punishment for criminal or delinquent conduct is intended to apply to all non-final judgments. That's, in light of the history that we've seen since 2012, ending with Prop 57, that is how I believe that the rationale and jurisprudence behind the Estrada holding would translate into today's world.
So the complication in this case is that the changes that Prop 57 wrought don't directly mitigate punishment. They involve an initial step of procedural judgments that are markedly dissimilar from the procedural judgments that were made pre-Prop 57. And I think that the question for us is how much should the complications involved in applying that set of procedural devices that look so different from the procedures that were in force before Prop 57 figure into our inquiry into the intent of the voters who enacted Prop 57. Did they really mean to send courts into reopening the cases that have been concluded for, we don't have a precise number of exactly how many people were affected, but hundreds of people were affected whose cases may be wrapped up with other defendants who may not be affected by Prop 57.
Okay, and so I'm going to try and break that question into two parts because I think in order to really understand the intent of the voters in adopting Prop 57, we have to go back and understand the intent of the voters in adopting Prop 21. Right? Because that's what Prop 57 undid. And I was very surprised, quite frankly, not to find any cases dealing with retroactive application of the direct filing requirements of Prop 21 and the statute that had been enacted right before it. I was also really surprised not to find any published cases dealing with ex post facto claims. And not only published, not unpublished either. There's nothing. And I thought to myself, how is it possible, truly, that not a single district attorney in the state of California who was prosecuting a case in juvenile court when Prop 21 happened could have thought to themselves, I know what I'm going to do. I'm not going to do this silly fitness hearing. I'm just going to go over here and I'm going to file an accusatory pleading because this isn't punishment. Remember, this is procedural. We're just changing the manner in which cases are filed. And the reason and then I thought maybe they did it and the entire defense bar was asleep at the wheel. And not a single juvenile lawyer thought to challenge that, and not a single appellate lawyer in a case where that had happened thought to raise an ex post facto claim. And then it occurred to me, no, the reason there's no law is because everybody understood that the changes of Prop 21 with regard to juvenile law, the amendments of 602 and 707 were geared toward punishment. They impacted punishment, and therefore they could not be applied retroactively without violating ex post facto prohibitions.
I will give you that. So I think there is a clear connection here between the procedures that we're talking about and the available punishments. And an overall ameliorative effect, at least for some category of offenders. But I guess the question is that all the voters, what reason do we have to believe that that is all the voters who enacted Prop 57 would have been concerned about in determining what the scope of application of these ameliorative changes ought to be?
And so this now takes me to my argument that, in fact, with regard to Pablo, that application of the law here was prospective. And let me see if I can do a better job of explaining that than I did in my opening brief on the merits. It's hard when you're coming to the Supreme Court having only written a letter, right? And you're really, because you're still processing all of this, but I've got it now. And it really comes back to looking at Welfare Institutions Code 654. And the voters are, 604, sorry. The voters are presumed to know about Welfare Institutions Code 604. It predates Prop 21. It wasn't amended by Prop 21. It wasn't amended by Prop 57. But I had to go back and read that statute because as a practitioner, I haven't actually dealt with it much. What that statute says is that at every stage, at any stage of a proceeding in the Superior Court, if a judge has reason to believe that the defendant before him was younger than 18 when the crime occurred, the court must, it's not even discretionary, must certify the matter to the juvenile court and permit the filing of a 602 petition, which now would also perhaps be accompanied by a 707 motion. I was concerned at first, thinking, well, clearly that wouldn't apply if jeopardy attached. And I see in 604, in the body of the statute itself, that it says if jeopardy has attached, then it still gets sent back. And it doesn't count as jeopardy. Now, I don't know that the legislature can really do that, to be honest with you. That's never been tested. I think the federal Constitution is probably going to govern whether jeopardy is attached rather than the statute. So I do find jeopardy to be a critical moment, and we weren't there in this case. Now, the reason that this was kind of an argument in the lower court, with the lower court, was the DA kept saying 604 doesn't apply to 707D cases, to direct filed cases. And I kept going back to the statute saying, it doesn't say that. It doesn't say that. And so I went back to figure out why he kept saying that. And it's because this court said that in Mandalay. When Prop 21 in the due process section, when Prop 21 added 707D, permitting direct filing, but failed to amend 604, this court in Mandalay said that was kind of an error. I mean, they just neglected to do it. It would be ridiculous to require the certification of cases that were legally direct filed, right? But then with Prop 57, 707D was eliminated. And so was the judicially created exception in Mandalay for direct filed cases. So what really happened in this case, which is quite straightforward, Pablo, day before the initiative became effective, Pablo was before a Superior Court judge as a criminal defendant. Because 707D existed at that time, and because of the judicially created rule of Mandalay, certification on that day would have been prohibited. The next day, 707D was eliminated, and with it, so was the judicially created exception of Mandalay. What Pablo's lawyer did was say, excuse me, hi, Your Honor, he was 14 or 15 at the time of the offense. You have no choice now but to certify him, suspend proceedings in the adult criminal case, which means that any procedurally significant events that have happened remain procedurally significant events should the case come back to adult court. That's what the statute actually says. Suspend the proceedings in the criminal case, certify the matter to juvenile court, permit the people to file a 602 petition. If they wish to move for transfer under 707, they can certainly do so. If the matter is transferred to adult court, proceedings resume in the adult court in the superior court case. If the matter is not, then the matter is taken care of in juvenile court. That's what 604 is. That's a prospective application. That truly is conduct of trials under Tapia. So if you want a bright line rule, I mean, that's not my job actually, but I mean, certainly if you're looking at 604 and you say at all stages in the superior court, you're looking at pending cases, and you're looking at cases that are reversed or even sent back for correction of sentence or resentencing on appeal, because those are going to come back to a superior court judge. I don't know what you do with those that are affirmed on appeal because they won't come back before the superior court. I don't know how you get there other than by Estrada. And you have so many options, so many cases in which you're going to have a chance to figure that out, right? But this isn't that case. This is a case that was pending pretrial. And the day that 707D disappeared, so did the judicially created exception of Mandalay. What the superior court did here by certifying this matter to juvenile court so that Pablo could be subject to a judicial determination, an evidence-based determination by an impartial fact finder without a presumption of unfitness, the totality of the circumstances analysis, what the court did was not only proper, it was mandatory. And that's why I think the Court of Appeal actually got it right when they applied Tapia to this particular procedural posture. I don't think that in my letter brief in the Court of Appeal, I don't think I really emphasized the importance of 604, and I don't know that I did it adequately in the answer brief on the merits, but I did certainly talk about it. I think 1170.17, I don't know what the application of that's going to be, but it certainly isn't going to be something that needs to be decided in the context of Pablo, who has not been subject to a judicial determination. Well, now he has, actually, and he's been found fit, but prior to proceedings being initiated in adult court, he had not been subject to a judicial determination of fitness. So
we're talking a lot about Estrada with respect to the retroactive piece, and we'll talk more about it perhaps. But supposing we had not decided Estrada, what would be your best argument that retroactive application is appropriate?
Had you not decided Estrada?
Correct. In other words, if we think about legislative purpose or structure or whatever you can find in the underlying proposition that supports your position, what is the best argument?
The best argument, and I didn't rely on Estrada in the lower court, and I didn't rely on Estrada in my answering brief on the merits, because I do see this as a prospective application of a change in the law, recognizing that. But
I take your point that there is an argument about some of this being prospective, but if any aspect of this looks retroactive to us, what, if anything, do you think one can find in Prop 57 that supports the conclusion that the purpose of Prop 57 cuts in favor of retroactive application?
I don't need the glasses. The purpose of Proposition 57 was to change the way that juveniles were treated in terms of being tried and potentially punished and sentenced. The voters recognized when they adopted Prop 57 that they wanted to be using rehabilitative dispositions for child offenders whenever possible, except in that rare case where, based on the totality of the circumstances, a judicial officer determined that wasn't feasible, that public safety could not be served, or that for whatever reason, the philosophy of juvenile law should not be applied. Because there is no clear statement in the initiative that they intended it to apply effective to crimes committed only after the effective date, or to charges filed after that date, or to cases pending. They didn't specify that. But the only justification one could possibly offer for applying this kind of broad remedial initiative to all cases going forward, but not to Pablo and the other maybe 300 kids who are pending these 707 hearings in the state, is because they are mad at these kids. They want to hurt these kids.
So is the possibility of reduced punishment an important part?
It is, Your Honor. It's very central to trying to ascertain legislative intent in this case.
Well,
and
isn't it even that kind of, in my mind, that's even kind of a misnomer, because if you proceed through way of Welfare and Institutions Code for a juvenile, then you're not talking about punishment. You're talking about rehabilitation. So we're really talking about two different sets of justice systems. And it's almost, so let me ask you, so in your view, for you to win, you don't even need to necessarily flex the Estrada rule. Your rule would be 604 applies and Prop 57 is prospective because 707D went away, as did the exception. So Estrada wasn't necessarily what you were going to argue. But I've heard you say, though, if you were asked about Estrada, which you were and you briefed it, was that Estrada applies here because it really is a global dimensional change to a process for juveniles. And if you were going to treat everyone but Pablo and people in his situation differently, it's just out of meanness because there's no rationale for it. And fiscal can't be that.
Yes, all of that is true. And I think fiscal was a component of this initiative. But if you think about the cost on the judicial system of doing jury trials in all of these cases versus a transfer hearing and a juvenile court, I mean, even if there's a jurisdictional hearing, even if the child doesn't admit the allegations of the petition, it's nothing in terms of resources compared to adult procedures and a jury trial. So I don't think that the cost-saving or judicial economy arguments are based in reality. I think they're actually contrary to what we all know to be true.
But of course, if we're talking about applying Estrada, we're not just talking about people who have yet to be tried. We're also talking about people who have been tried, but whose judgments just haven't become final yet.
Yes, that is absolutely true. If the court decides this case, if the court disagrees with me about the prospective application, which I won't take it personally, and that's fine, and decides this case on Estrada grounds, then you are deciding it not just for Pablo and those who are similarly situated, but you are articulating a rule that would have broader application. It would apply to cases that are not yet final on appeal. And I get that changes the burden, but I don't think that that's a reason not to apply a principle, not just the Estrada holding, but the rationale of that case that goes back to, to common law. So,
can you address, counsel, the practicality dimensions that your colleague on the other side raised? So these are, yes.
In the pending cases?
Well, these cases that have been litigated to judgment already, and now we have to go back to, in essence, square one, and you have a fitness hearing to determine the appropriateness of transfer. And your colleague on their side spoke of questions like, what do you do with the evidence that was in the prior proceeding? What do you do about situations where there were multiple defendants, some of whom were appropriately tried in criminal court and others not?
So let me try and separate those on appeal cases into a couple of piles.
Okay.
Those that are reversed on appeal, where there's no conviction, those are treated like Pablo's case. Those are pending cases. They get certified under 604. The people file a 602 petition. Defendant's quite a bit older, so people can stipulate to doing things and not have a hearing or whatever, but that would be the process for those cases. So does that make sense? Mm-hmm. There are the cases that are affirmed on appeal, where the conviction is affirmed on appeal, and then the only question then would be, do you remand so that a certification can be done and a new 602 petition can be filed with a new 707 motion and a new jurisdictional hearing? And I don't think the Estrada rule would require that. I think that 1170.17 actually serves that purpose, because if you apply the changes to 707 to 1170.17 and you recognize that there are no longer any presumptions of unfitness to be treated as a juvenile, anyone who is post-conviction would be entitled to have a dispositional, basically a fitness hearing for the purpose of determining the proper disposition. Those folks actually had more protections, more due process than the juveniles whose cases were adjudicated in juvenile court because they had a right to a jury trial. And so there's that. I think that might be a way of handling those cases, if you want to, my opinion, as to I don't think the impact is huge because quite frankly, when you have a 28-year-old defendant coming back for a fitness determination, I mean, I think it's really important that the hearing be done, because that information, if the person does remain sentenced as an adult, that information is going to be part of the person's central file at prison and is going to be considered at a youth offender parole eligibility hearing. So it's not a waste of time. It's actually work that has to be done one way or another. Those cases are going to get, let me put it this way, if they're not sent back for an 1170.17, they're going to be sent back for a Franklin sentencing. So the work's going to get done. The hearing has to happen. Whether this court applying Estrada and upholding the principles on which it's based doesn't create any additional burden with regard to those cases. I'm going to stop because... Okay, thank you.
Thank you. The greatest concern for me here is the disruption in these cases, and it is what is going to happen in these cases moving forward. The drafters of initiative know how to avoid that disruption by writing in a procedural mechanism to apply this to people after they've been convicted, after they've been sentenced. It's what they did with Prop 47. It's what they did with Prop 64. They're avoiding that disruption by providing that procedural mechanism. Here, not providing that procedural mechanism doesn't only create the great disruption in all of these cases, it indicates an intent not to apply it to these people. If there was an intent to apply this to people after they've been convicted and after they've been sentenced, the drafters of this very initiative would have included it as to this portion of this initiative like they did to the other portion of this initiative, to the other half of Prop 57. They know how to avoid that disruption if they want to. Here, they chose not to do it. That lack of a procedural mechanism is very telling. And again, Estrada has never once been applied this broadly. And I think that is a good reason why, of the now 10 published cases addressing Prop 57, 8 of them concluded Estrada doesn't apply, including this case. I think there's a reason Real Party all along has concluded Estrada doesn't apply, because it's never been applied in this fashion ever before. And if it's applied in this case, if this court were to walk down that very dangerous path of applying it in this case, we're going to be delivering to the voters a very different law than what they voted on, and a very different law than they intended. So with that, unless the court has any questions, I will submit.
Thank you, Mr. Ostertag. Thank you, Ms. Arnold. The matter is submitted. Calling the matter of People versus Todd Jesse Garton, and we welcome the Honorable Charles S. Perchigian, Associate Justice, Court of Appeal, Appellate, DCA 5. Welcome. You may proceed, Counsel.
Thank you. Your Honor, may I reserve 5 minutes for rebuttal?
Yes, Mr. Gale.
Good afternoon. May it please the Court, I'm Jeffrey Gale. I represent Mr. Garton, the appellant in this case. With the Court's permission, I would like to discuss what I view as the faulty conspiracy instructions which were given in this case, which I submit rendered both the guilt and the penalty verdicts in the case invalid. There were 3 conspiracies. In addition to the 2 murder counts, there were 3 conspiracies to murder charged in this case. With respect to each of those conspiracies, there were at least three potential conspirators. In the case of Carol Garton and her fetus, her unborn fetus, there were three potential conspirators, and in the case of Dean Noyes in Oregon, there were 4 potential conspirators. The jury instruction that the court gave the jury in this case, a faulty version, a modified version of CalJIT 8.69, informed the jury in defining conspiracy that only 2 of the 3 people in the first 2 conspiracies and 2 of the 4 in the latter had to harbor malice aforethought, and specifically an intent to kill. And under the versions of the instruction, the jury was permitted to find, for example, in the Oregon conspiracy, that Dale Gordon and Norman Daniels agreed to kill Mr. Noyes, and that both of them harbored malice of forethought. And
So it seems that the wording is incorrect, and the government acknowledges that.
Yes, sir.
So, what do you say in response to the? Let's just focus on the victim, Carol, and her fetus. What do you say in response to the government's argument as to why that is harmless in light of the finding of the special circumstances?
Well, I think the multiple murder special circumstances rely on the definition in this conspiracy instruction. Go back to that. I think the financial gain special circumstance presents a much more difficult case with respect to Carol Garton and her fetus, Your Honor. But I think with respect, and if the court is inclined to find the intent provided by, in those determinations with respect to Carol Garton and her fetus, there's still the issue of Dean Noyes and the conspiracy in Oregon, and there's no finding of intent with respect to the Oregon conspiracy, which the jury took into consideration both in guilt and, of course, in the penalty phase.
Well, just focusing on Carol and her fetus, I take it, I mean, the relevant instruction here says that if you find Mr. Garton was not the actual killer of a human being, you cannot find the special circumstance to be true unless you're satisfied beyond the reasonable doubt that Mr. Garton, with the intent to kill, aided, abetted, counseled, commanded, induced, solicited, requested, or assisted any actor in the commission of that crime. And I think with respect to those murders, of course, there is no contention here that he was the actual killer. Everyone agrees that it was Daniels who did it. So the jury could not have rendered that verdict without finding an intent to kill by Mr. Garton. Isn't that right?
If the record, Your Honor, the jury was instructed with aiding and abetting, and the jury could have found that aiding and abetting, and absent the confusion in this instruction, may have rendered a different verdict on that. I concede that the aiding and abetting instruction is in the Attorney General's brief. The jury was instructed with aiding and abetting, and they did find the special circumstances to be true, which weakens my case a little. And I think with respect to the guilt phase particularly, but in the penalty phase, Your Honor, and particularly with respect to the Dean Noyes
Can you speak to that then? What do you think, supposing that there was some error in the conspiracy, the conspiracy to kill Dean Noyes, what does that get you in terms of the penalty phase?
Well, all of the evidence that was of the conspiracy to murder, the jury in this case could have believed entirely Mr. Garton's defense with respect to the Oregon escapade, and still under these instructions have found him guilty. And all of that evidence with respect to Dean Noyes in Oregon, the trips to Oregon and taking weapons and going to her house and going to the hotel, all of that was improperly in front of the jury with respect to this conspiracy conviction at the penalty phase.
And your argument that somehow that inflamed the jury more so than the fact that Mr. Garton stood convicted of hiring someone to murder his wife and unborn fetus?
I don't think it helped adding a second conspiracy to kill his girlfriend's husband.
Even though he failed in that effort?
Even though he failed, I can't see how that would have not impacted a jury, notwithstanding the facts of his wife and the murder. The conspiracy and the entire case was about Lynn Noyes, I believe, that Lynn Noyes, going back to high school, and their romantic relationship over the years, and the prosecutor said this was the reason, I believe was the motive for the murder, that Todd wanted to be with with Lynn Noyes.
Well, that may have been part of it, but wasn't also, I mean, as has been indicated, the special circumstance that Mr. Garton was found true against was he murdered his wife for financial gain after he took out a life insurance policy on her, didn't? I mean, that was clearly before the jury. They found so.
That was one of the findings, and then that's not good evidence to have to deal with, but neither is an additional conspiracy that we were trying to kill.
Well, I don't know. I mean, you said a second ago that the evidence wouldn't have come in the penalty. That's not exactly true, is it? It's just that the conviction could not have been relied upon by the prosecution in the penalty phase argument, but all the evidence, if properly admitted, would have been properly heard by the jury. It's just that the jury could not have found him guilty of the conspiracy, but it's not that the jury could not have considered that he took various steps towards the conspiracy and it exhibited whatever inference they chose to draw from that. Just that it's not a conspiracy, but they can still draw whatever inference they want from it, just from the mere fact that the evidence was properly admitted.
Had the evidence been properly admitted, yeah, I believe you're correct. But the conviction, the evidence of the conviction was also weighed in the penalty phase and in determining the appropriateness of the penalty. Your Honor, and I think throwing that, I think that in those situations, it is impossible to look at that and say beyond a reasonable doubt that conspiracy conviction did not contribute to the verdict in this case.
It seems to me the prosecution closing statement at penalty focused really on the killing of the wife and fetus. Are there a lot of statements regarding the conspiracy to kill Noyes?
I did not read the closing argument before.
It seems to me there's very scant mention of it. I mean, that is not even remotely the primary argument made by the prosecution.
I don't know about the closing argument, but I do know that during the case that the adventure in Oregon and the several trips to Oregon to kill Dean Noyes were a crucial part of this case in order to establish the connection between Lynn Noyes and Todd Garton and their romantic relationship and the efforts to kill her husband so they could be together. I think it was not the primary focus of the prosecutor, but it was certainly a primary theme, a weighty theme throughout the case that the prosecutor urged on. And I can't tell you from the closing argument, I do know the prosecutor stressed his efforts that he did deserve to be condemned to die for his efforts to kill Dean Noyes. Unless there are other questions, Your Honor, I will surrender my time and answer any questions in rebuttal.
Thank you, Mr. Gale.
Thank you.
Good afternoon. May it please the Court. Although the trial court included an incorrect phrase in the conspiracy instruction, CalJIC 8.69, there is no reasonable likelihood that the jury interpreted that instruction and the instructions as a whole to allow it to convict Mr. Garton without finding that he had the specific intent to enter into the conspiracy and without also finding he had the specific intent to kill the victims. There are other portions of CalJIC 8.69 which would have strongly indicated to the jury that all of the conspirators needed to have that special intent. The entire first portion of the instruction before it talks about the elements of the offense talk about a conspiracy as requiring a specific intent on the part of the conspirators, that the conspirators have to have harbored express malice aforethought. Of course, Mr. Garton was the only conspirator here who was on trial, so that would have applied to him. And then finally, in order to find Mr. Garton guilty of conspiracy, in addition to proof of the unlawful agreement and specific intent, there must be a commission of at least one of the overt acts. That sentence strongly implies that Mr. Garton had to have the specific intent to be found guilty of this charge. In addition to those other portions of CalJIC 8.69, the jury was also instructed that, I think it's CalJIC 3.31, that for any of the counts charged, 1, 2, 3, 4, and 5, there must exist a union or joint operation of act or conduct and a certain specific intent in the mind of the perpetrator. And Mr. Garton is the perpetrator in all of those counts, and so the jury would have had to have found he had the specific intent there. In addition, as Justice Liu was pointing out, the instructions on the special circumstances required the jury to find that Mr. Garton personally had specific intent to commit the murders or to aid and abet in the committing of the murders. So that would have been another indicator that the jury could not have reasonably concluded that Mr. Garton would be guilty of conspiracy if they found that he was not one of the people who entered into the agreement and had the intent to kill.
If the jury found that Mr. Garton with intent to kill aided and abetted Daniel's killing of Carol and her fetus, does that necessarily establish that he was also guilty of entering into an agreement to perform the killing?
I don't know that alone necessarily requires that type of a finding, but when you look at the evidence in this case that was presented, and you look at the argument of the prosecutor, which was that Mr. Garton was the mastermind of a plot to kill his pregnant wife, all of the evidence in this case supported that.
So it would have been unreasonable for a jury to determine that he had only aided and abetted and had not entered into a conspiracy?
Yes.
Is that the idea?
Yes, because the entire theory of the case was that he was not just an aider and abetter, but he was the mastermind of the conspiracy as well. If I could address one of the points that my colleague was making about how the conspiracy instruction may have bled over into the murder counts, I don't think that is a fair reading of the record. The prosecutor in this case argued a single theory of murder, which was aiding and abetting. This is as pertains to counts 1 and 2, the murder of his wife and her fetus. The only theory was aiding and abetting, that he aided and abetted Norm Daniels to carry out this murder. The prosecutor did not argue conspiracy as a theory of murder. He argued conspiracy only as a theory to support the 3 conspiracy counts. And so I don't think the jury would have been confused that if he was a conspirator, that necessarily meant he was also an aider and abetter, because they were separate counts, separate theories. As far as the impact on the penalty phase, again, as Justice Liu pointed out, the prosecutor's argument in the penalty phase was devoted almost entirely to the circumstances of the killing of Carol Garton and her fetus. That, in fact, the count of conspiracy to kill Dean Noyes was not a basis for the murder charge. It would not have been a basis to sustain the special circumstances leading to an imposition of a death sentence. So it couldn't have had an effect on whether the jury decided that he should be put to death. Unless this court has any questions on this issue or any other issues, I'm prepared to submit.
Thank you, Mr. Bernstein.
Just one brief item in rebuttal. Mr. Bernstein talks about other portions of the instructions which the jury could have relied on, and I think that's the problem. We don't know what the jury relied on. In this case, the jury was instructed that in the conspiracy definition, in the elements of the conspiracy, you must find, and I submit that is where the jury, if they were looking for instructions rather than looking in other conspiracy instructions and elsewhere, would have looked right at these elements, and they were informed that one of the elements, 2 or more persons entered into an agreement to kill. In Dean Noyes' conspiracy, that could either have been Lynn Noyes, Norm Daniels, or Dale Gordon. And that was Mr. Garton's defense. The jury could have believed every bit of Mr. Garton's defense in this case and still found him guilty. He told the jury, I didn't do this. They framed me. That was his entire I don't know anything about it, and they framed me. And under these instructions, the jury was permitted to find that Norm Daniels and Dale Gordon and Lynn Noyes entered into an agreement, harbored malice aforethought, did exactly what Mr. Garton's defense was, and still allowed him to find him guilty of a conspiracy and sentence him to death based on those conspiracies. So to the extent the other portions of the instructions might have said something different, it only created, and I would submit, more confusion in this case. And I think People versus Wilkins, the course, it's not an erroneous instruction. This is a misinstruction on the jury. It's not a failure to instruct the jury. This was an outright misinstruction of the jury, as this is what it takes to find a conspiracy. And the problem in this case, of course, is that was Mr. Garton's defense. I didn't do this. Dale Gordon and Norm Daniels and Lynn Noyes did all of this. I wasn't there. And the jury could have believed that in this case and still found him guilty and sentenced him to death. So I would submit that the other portions of the instructions, the court should look at this instruction and take into consideration the conspiracy evidence and the impact it had on at least the death verdict in this case, if not the guilt verdict, and reverse the case. Thank you, Your Honors.
Thank you, Mr. Gale. Thank you, Mr. Bernstein. The matter is submitted. We stand in recess until tomorrow morning.
All rise.